Coming up in all angles, the Auditor General's report, tabled but out of bounds.
I shall prevent the members of the House from entering into any debate and/or discussion.
Revolt in the House.
You are going to order them to sing. This is no school principal business. I am no child.
But what are the very serious concerns, and will there be action this time around? Thank you so much for joining us for another edition of All Angles. I'm DIONNE Miller, and our guest for this program, we have with us in studio Howard Mitchell. He is the chair of the Jamaica Accountability Meter Portal. Also with us, the opposition spokesman on education, Peter Bunting, and human rights activist Susan Gough. Before them, though, we are going to first of all go to Parliament, where the Speaker of the House of Representatives, Colonel Charles, yesterday did say he was tabling the Auditor General's report into the Caribbean Maritime University, but let's go to that.
The contents of the Auditor General report and the CMU have a direct bearing on matters pertaining to the arrest and charge of persons whose trials are pending in the parish court at St. Andrew. It behoves the Speaker, the member of the House, and indeed the wider citizenry, to ensure that persons who are on trial get a fair trial based on the evidence that is led in court and not by extraneous matters, including material presented in the House of Representatives. I shall prevent the members of the House from entering into any debate and/or discussion of the said report in a manner that would prejudice the fair trial of persons who are charged.
Are you prepared to share with the members of the House the basis of the legal advice on the constitutional matters which you presented to the House? Did you receive advice or did you advise yourself?
Dr. Phillips, as the Speaker of the House, and one who is qualified, and one who has been to a university like you, and have obtained a degree in government, I advise myself according to the standing order and the Constitution. I have a brother who is an attorney, I have not applied to him. I have a son who is an attorney, I did not apply to him. I applied to my own studies as one who have studied at an appropriate university and advised myself.
Well, I decided not to advise myself, so I went to ask Attorney at Law Gordon Robinson for his take. There's been a debate as to the CMU report and its tabling in Parliament. Now, the Speaker said in Parliament yesterday that he would table the report, but that he would prevent any debate or discussion by members that would prejudice a fair trial of the persons before the court in connection with issues related to CMU. Is he on strong ground there?
DIONNE, I feel like Tony and Singh on the questions from Piers Morgan because I'm going to cry. The actions of the Speaker, in my opinion, have already undermined and are continuing to undermine the role of Parliament. Parliament has two obligations only. Number one is to pass laws for the peace, order, and good government of Jamaica. And number two is to ensure peace, order, and good government of Jamaica by the government agencies, so that this is done, again, set up constitutionally by the standing committees and by the reports like the Auditor General's report. It's Parliament's obligation obligation to discuss these reports.
You're talking there about the oversight function.
Yes, it is in the Constitution, believe it or not, that oversight function, because the Constitution allows Parliament to regulate its own procedure by standing orders, and the standing orders set up these committees. So if you do anything to restrict the activity of these committees or the oversight role of Parliament, and remember, Parliament and government is separate in theory, then you are undermining Parliament. It has absolutely nothing to do with a fair trial.
How so, though? Because in speaking with Attorney Lloyd Barnett a couple of days ago, he said in his view the Constitution did compel the Speaker to table the report from the Auditor General, but that he believed their Parliament could prevent its further dissemination or discussion, again invoking the idea of a fair trial. That
could only happen in a Parliament that is supreme, which unfortunately is not so in Jamaica. Sorry, fortunately is not so in Jamaica. In a country where a Parliament is supreme, yes, Parliament could do that. But in this country, the right to a fair trial is completely separate to the role of Parliament. And the right to a fair trial means three things only. One, no undue delay. Two, fair and impartial and independent tribunal to try the case. And thirdly, no conduct by the judge or the prosecution that would be unfair to the accused person. And this is why we have rules of evidence and we have a trained judge to make sure that a jury only sees certain things, only considers certain things, even if extraneous material should be in the ether, because there's a difference between the courts and the Parliament. In our Constitution, they are separate, and never the twain shall meet, except that the court is set up to ensure that Parliament obeys the Constitution.
But don't you have, well, at least some might argue that what you have is actually a clash of constitutional principles, which is the constitutional principle to the right to a fair trial, and the various imperatives in relation to how Parliament should work and that oversight function.
You do have those two things, but they don't clash. Because, as I say, the elements of a fair trial have nothing to do with what happens in Parliament.
Except you spoke about the need for a fair and impartial tribunal.
Correct.
And the concern has always been that you don't want to put material, you said extraneous material, but you don't want to put material into the public that could influence the tribunal, the judge or the jury in whichever case.
And that's just what I'm saying. You can't.
How so?
Because what is in the public domain, so to speak, cannot come into the trial except it is permitted by the rules of evidence. And a judge who tries a case by himself, we don't have a problem with that. A judge who tries a case with a jury will ensure that the jury does not consider anything that is not evidence in the case. If that should happen, we have a court of appeal.
But isn't that kind of artificial, expecting the tribunal, the judge or the jury to close off their mind to what is out there, what is being reported, what is being said, what is being discussed?
Yes, it is somewhat artificial, but it's the only way to go. Because remember, the Constitution also guarantees every citizen the freedom to disseminate his or her opinion through any media. So you have to consider all of these constitutional issues. And you have to have a system that tries its best to keep them separate. Now, no system is perfect. And of course, human beings will err. But that doesn't mean that the system prevents Parliament from being Parliament.
But it is because of those considerations that the rule was developed that you shouldn't talk about trials, you shouldn't discuss them, and so on. And in fact, we're not the only constitutional democracy that abides by those rules. So the other countries in the Commonwealth, for instance, also have similar rules because of that same justification. You don't want to influence a judge or jury.
Except that I keep insisting that the judge cannot be influenced. Sorry. Ought not to be influenced. That's why he or she is a trained judge. And that the jury's influence is limited by the instructions given by the judge. It's all very well and good to talk about what happens elsewhere. But remember again, we do have freedom of opinion. And so how we work it is, you are free to give your opinion, And the judge is there to make sure, or to try to make sure, that your opinion doesn't influence the jury.
You're free to give your opinion, but that can be restricted based on what is demonstrably justified in a free and fair society.
Correct.
Right.
But that would have to be by law.
Or looking at the other constitutional principles we're talking about and the rights and freedoms of others.
Well, yes, but I don't see any other constitutional principle. Remember, we have a written constitution in this country. All constitutional principles come from the Constitution, nowhere else. And so, unless the Constitution restricts that freedom of opinion, and as you quite rightly say, it does, if Parliament passes a law that's demonstrably justified and so on and so forth. But no such law has been passed.
So the prohibition then, going back to where we started, that the Speaker gave, you think should be, is of no effect?
I'm not sure it's of no effect. We'll see what effect it has. What I am sure of is that it is unconstitutional.
So if you were a member of the opposition, you would do what? Who felt inclined to discuss or debate contrary to what the Speaker
I would
said?
exercise my freedom of opinion. I would make sure I follow my constitutionally parliamentary role. I would discuss, debate, examine, and inquire into that report to my heart's content until such time as I am locked up for treason.
Or contempt of Parliament?
Or contempt of Parliament, if there is such a creature. I haven't found that creature in my constitution. I've heard about it in England.